Well, good morning, everybody. Welcome to the Mediators New Breakfast Club. In a break from our normal practice, we're actually going to ask people attending for the first time to introduce themselves at the end because we have some time pressures. It's my pleasure to introduce the annual session from the Civil Mediation Council. And we have with us Rebecca Clark, who's currently the Deputy Chair and Chair Designate, and then Paul Adams, who's the CEO. And Paul is going to go first. So over to you, Paul.
Excellent. Thank you very much. Welcome all. As Michael has said, this is a sort of annual event. We try to come and brief through this session in the spring each year. I think this is the third or fourth time I've done it. And really, it's an opportunity for us just to give you a bit of a heads up as to what's going on, but also to answer questions, because I'm aware that you may have questions, and very often we find that multiple people have got the same questions. So hopefully, it's an opportunity for us to answer those in an efficient manner. I wonder, is it possible just for me to share screen for a second? Yeah, possible. I just really wanted to touch on a couple of things, really just to answer some misconceptions, I think, about the CMC, and also to show you how we try to run the organization in support of our charitable articles. So most of you will be aware that the CMC is a charity. And because of the way we function essentially as a professional members association, we always walk a line between charitable status and professional members association. Other organizations, FMC as an example, are not a charity, and in some ways that makes their operating structure much easier. College of Mediators is another one that's not a charity. So why do we continue with our charitable status? Firstly, because it's historical, but secondly, because it gives us leverage, especially when talking to government, because we're not seen to be pursuing commercial interests. Okay, so it's vitally important that we hang on to our charitable status, especially at the moment when we're in a potentially a moment of change with government. But it does mean that there's limitations to some of what we can do, and it does mean that we have to ensure that how we function is in support of those charitable articles. Luckily, we only have two, which makes it more straightforward, and those are essentially promote resolution of conflict and dispute via mediation, and it's to educate the public in matters of mediation, essentially to encourage the use of mediation. How do we support that? Well, we support it in a number of ways. I hope you can see that. I can't actually get to my minor technical issue. There we go. Let's see if we can get that a bit. Yeah. Excuse me for a second. Okay, hopefully you can see that a little bit more clearly now. Okay, so you can see from here that everything that we do is in support of those two charitable articles, the educate and the promote. And very much on the education side, it's focused on supporting mediators. So we've essentially two sides to it, one of which is very much on the regulatory side. And you can see that we support that through both the Complaints and Discipline Committee and our registration and standards. Now, those are crucially important, especially in a sector which is essentially unregulated. And, the view of government, or the concern of government when it comes to increasing the support for mediation, particularly with reference to automatic referrals to mediation, is the unregulated nature of the sector. And so a lot of what we're doing on the one hand, on the regulation side, is to make sure that mediation is seen as a proper, mature profession with good quality standards that translate well when those outside of the sector look in, that we can justify the decisions that we make in terms of how mediators are trained and how they're regulated, and that we're able to inspire confidence, particularly in the government, in a scenario where mediation is much more widely utilized than it is today. You know, we're winning that battle. Confidence with government is improving. If you go onto any of the government websites that mention mediation now, those links will either take you to the Family Mediation Council if it's family related, or bring you to the CMC if it's a civil commercial situation. So that side of what we do is crucially important. To support the promotion of mediation, and this is an area where members are always very keen that we do more. We essentially promote mediation in three ways. We promote it within the sector, and that's essentially a consultation piece, looking at how can we work, how can we help mediators promote mediation themselves? How can we work with other partners within the sector, other organizations, FMC, College Mediators being two cracking examples, to further the cause of mediation? And how can we develop mediation within specific areas? So you'll see there on the diagram, things like community mediation is something that we're just getting a new working group into. Peer mediation is something that we've run a 12-month pilot project with the Peer Mediation Network, looking at how we can support the work that they've done already. And we're coming to the conclusion of that project now, and so hopefully there'll be some good news in the very near future about how we might pursue that going forward. So that's very much the consult piece, and included in there is our events, which is, as you know, the two big events really is the annual conference, which last year we ran jointly with the College of Mediators. That's the first time that we've done that, and again that's part of our desire to join up the sector essentially, and enable the sector to speak with one voice. National Mediation Awards, they're every other year. The next edition of National Mediation Awards is going to be this autumn, held in the House of Commons. And that for the first time is going to be a properly pan-sector event. So that will include College of Mediators, ourselves and the FMC as joint in a joint venture. And so it will span the full spectrum of mediation, from family through peer mediation, through community, through civil commercial. So that that's the first time that the sector has done something totally pan-sector, and so that's encouraging for the future, and it shows that we're making progress. So that's very much the consult piece. The inform piece, which is public facing, and this is always something that mediators want us to do more of. We also want to do more. The issue is always resource. We receive no funding other than that we receive from our membership fees, and therefore we are always operating within a tight resource envelope. What does that mean? Well, it means we try to operate as efficiently as possible. So there are no offices. Everybody works on a contract basis. We do our best to maximize the output of the organization with the resources we've got. Could we do more? Yes, of course we could do more, but that would require more resources. So we're in a sort of chicken and egg scenario. And that is why we do what we can, but our focus is probably more, especially at the minute, on the last piece, which is the influence piece. And that is very much about how can we persuade government to incorporate mediation as a sort of built-in element to the judicial process. The strategy that we wrote back in 2019 very much focused on the need for automatic referral to mediation. So ARM, that's not compulsory mediation, but that's automatic referral. So it would be an opt-out rather than an opt-in scenario. And we've been pursuing that for 2.5 years. We are definitely a lot closer to it than we were 2.5 years ago. Are we there yet? No. Unfortunately, Lord Wolfson has just resigned, which is definitely far from ideal, because he was extremely positive about mediation and we were making real traction. But we've had the call for evidence from government from last year. The results that came back in March, that was positive.
You got a fire alarm going on there.
Sorry about that. There's nothing like a public announcement, is there, right in the middle of a spiel? So I spared you that, I hope. Yeah, so the government piece is super important, and really, strategically speaking, it's vital to the future of mediation, and that's why we're trying to support and influence and guide and advise government as much as possible, right at this moment in time. It's something that Rebecca and Hetty Jackson-Stopps has been very involved in, and something that has potential to be a game changer for mediation going forward. But obviously we're not in charge of the process, and it requires constant support, and our finding so far is that if you don't support it, government is looking for a solution, and if we don't guide that solution, you're going to end up with a solution that you don't like. So that is sort of front and center of our strategy at the minute. Yeah, so hopefully that gives you a very quick sort of overview of where we are. And, as I say, we do have these two charitable articles, these two charitable objectives. And so everything that we do has to be geared towards that. We often get asked why we can't essentially help members get more work. Well, we can't help members get more work because we're a charity, and that doesn't support our charitable objectives. Okay, so, what we aim to do is to further the causes of mediation by ensuring that it's seen as a well-run professional sector that can be trusted, and then we try to spread that word to anyone who will listen, essentially. Okay, that's probably more than enough from me. Rebecca, did you want to say anything?
Thank you very much for that, Paul. I am really keen to answer any questions that any of you guys have about this CMC going forward. I had lots of questions. I became deputy chair a year ago, and to be perfectly honest, I had no idea of the amount of work that's done by the CMC until I actually became deputy chair. And we need to be better at telling people what we're doing. And Paul's mentioned that we're a charity and we're funded by membership subscriptions, which is correct. So Paul and Helen's team, they are paid on a contract basis. Everybody else working at the CMC is a volunteer. So I can see Roger's here, he's a volunteer, I'm a volunteer. So I'm really keen to talk to you guys and understand what questions you might have, how you want to use this time. We're at a time of great change within the mediation profession. We've got Sir Geoffrey Voss looking at overhauling the court system and having this funnel where all cases are funneled down through online platforms and kind of fast forwarded into some form of mediation process. We've got this request for evidence from the Ministry of Justice that Hetty and I talked about. In fact, I'm meeting Lord Wolfson this afternoon to talk about how we move things forward within government. There's loads of different things going on within the CMC, reflective of the change in the government's approach, really, and the pressure on the courts. So we're at quite an exciting time. And the challenge for us at the CMC is to make sure that we're at the forefront of everything that's happening in terms of change so that we can influence it. We've had lots of conversations with government, even over the last few weeks, where people making decisions about dispute resolution still don't really understand what mediation is, and they don't understand how the mediation market works. And that's obviously quite concerning. So we're spending quite a lot of time talking and educating government and people at the Ministry of Justice around that, on the basis that, as Paul said, if we don't do that, we're going to have something imposed on us. It is going to change. The government is looking at regulating the market. We're very keen that we're involved and that we provide some proactive solutions to all of that. And at the same time, we're doing our normal regulatory functions in terms of registration and standards. As Paul said, we're doing the conference, the National Mediation Awards. We've just launched a new website. So there's loads and loads of stuff going on. But I'm happy to talk about whatever you guys want to know about.
Rebecca, sorry, I just wonder whether I might kick it off. Do you think anybody in the government or the judiciary actually gets all this? You know, I worry that wherever I go overseas, governments, doesn't matter whether it's the Kingdom of Saudi Arabia, Hong Kong, although we probably ignore them now, Singapore and so on, and put massive backing behind what essentially we're talking about, you know, the broader forms of ADR, you know, mediation, arbitration and so on. And I'm not sure, I'd be interested in your take on whether the government gets it, and also whether the government gets what a big business is. I mean, I did a tot up a while back with somebody from the grain of from GAFTA, and it's easy to get to this, what we do being worth at least £1 billion a year to a UK PLC.
Well, that's interesting. I'd be really interested to see that, Michael, because that's something that we could definitely refer to.
We did it on the back of a menu, but I could try and reconstruct it. Okay,
that's fine.
It will have only got bigger.
No, that would be really helpful. I think there's two answers to that. I think some people in government really get it. Lord Wolfson really got it because he was obviously a commercial silk. He was involved in mediation, so he had quite a good understanding, certainly of the commercial mediation market. The people that we speak to at the Ministry of Justice, I think it's quite a mixed picture. I think some of them really understand it, and lots of them really don't understand it. And in particular, they don't seem to understand how the market works, and that's quite concerning. So we spent a lot of time educating them about what the CMC is and the regulatory function that it performs, and how the membership works. They seem to believe that the market is really fractured, and it's in many ways it is, but actually from a CMC perspective, we've got over 700 individual members. We've got all the main training providers registered with us, and many of the larger kind of mediation chambers registered with us. And so all of those people are subject to the regulation and the disciplinary and the standards that the CMC has devised. And I think that people don't necessarily understand that. So I suppose, Michael, I would say it's a really mixed picture. And sometimes we come away from these meetings and we feel really enthusiastic and, oh, this is great, we're really making progress. And sometimes we come away and think, oh my goodness, you know, this could just be a car crash if we don't speak to the right people at the right time. And it's tricky because then as soon as you start making some relationships with people, they get moved off into a different department and you have to start all over again, which is really frustrating, to be honest.
Yeah, I would echo Rebecca's comment there. You know, you spend 18 months ensuring a specific individual really understands what's going on, and just as you get to the point where they, from our perspective, become useful, or from mediation's perspective become useful, they then get shipped off somewhere else. And you know, with Lord Wolfson, obviously the period required for him to be pro mediation was much smaller, and he was, you know, very vocal in his support. So yeah, losing him is definitely an issue. I think, you know, again, as Rebecca said, the pitch to government is this simple. If rather than going down very expensive route of heavy legislation, which will be slow and expensive, if you limit access to future government schemes to the CMC and the FMC members in their respective areas, you get regulation overnight, because obviously our members are regulated, and so are the FMC's members, and you're already seeing that more in the family context, where FMC membership is a requirement for specific schemes. The advantage of that is, one, it provides the government with a quick and easy solution. And I think obviously COVID has been catastrophic in a lot of ways, but actually I think for CMC and for mediation, it's been fantastic. It's been fantastic, one, because it's ratcheted up the pressure on the court system, which was already creaking. And secondly, it has encouraged innovation within mediation, specifically the idea that mediations can effectively be done online, and that massively increases the reach and the scope of where mediation can be used, and reduces the cost. So for all those things, I think, you know, we're in a positive situation. I guess the final aspect to it is, if we can persuade government to go down the CMC FMC route, then it will bring the sector together, because you know, one of the things I've said ever since I've been in post is, we need to get to a point where CMC or FMC membership is a business necessity for any mediator. You know, it's not negotiable. It's one of those things that, you know, it's number one on the list. You have to do it. Obviously, mediators become frustrated about the amount of work that's available. Some mediators do, particularly new mediators. Well, actually, if the government goes down this route, and CMC or FMC membership is a prerequisite to access to essentially those work streams, then everybody wins, because, you know, there'll be far more work for the mediation community. The government gets a massive problem off its hands, and the public gets access to better, cheaper route to resolution, which you know, with better outcomes. So everybody's a winner here. And so that's the message that we're sort of trying to portray.
That's great. Just but one very quick observation. There's a deal to be done here, I think, which also involves mediators having statutory immunity from suit and entitlement to reasonable fees, as arbitrators are. So that's the sort of bit of a carrot for the mediation community.
Michael, Graham Hallows would like to ask a question.
Okay, Graham, where are you? Hello.
I'm here.
Oh, hi. Good morning.
Good morning, everybody.
Hi, Graham.
Yes, this may actually be a silly question, because I suppose it depends on the legal foundation. But is this a conversation that's just ongoing with Westminster, or is it a conversation that you're having with the devolved governments as well, in terms of promoting mediation?
It's not a silly question. At the moment, we're having the discussions with Westminster. I, in fact, had a good conversation with John Sturrock about the mediation position in Scotland yesterday, and he is putting me in touch with Scottish mediation, which I appreciate is not Scottish government, but, you know, it's a step in the right direction. My understanding, in particular in Scotland, is the mediation situation is quite different and not as widely accepted. So I think at the moment we're pushing through Westminster, not least because Westminster kind of opened the door with the call for evidence, which gave us a good route in to these people. Does that answer your question, Graham?
Yes, I suppose it does. I mean, my particular interest was whether there's any avenues with Wales, which is where I'm based, because the Welsh government do particularly like to be as different to the English government as they possibly can be.
That's what John said about Scotland as well, actually.
Yeah,
I think, I don't know exactly, and this is my lack of knowledge. Given that it's the court system of England and Wales,
yeah,
I don't understand what remit the MOJ has over Wales in terms of court rules. I would assume that Wales and England are aligned in relation to court procedure.
Mhm.
But happy to have a chat with you, Graham, about that, because definitely if there's some route in via the Welsh Government, we're definitely up for that.
Yeah, okay, quite happy to do that offline, because there are sort of contacts that can be shared. I was thinking, I didn't think they'd have the authority or the devolved powers to change the statute book, but in terms of the promotion of mediation as a route to settlement, then they may well see that as an option. But anyway, yes, happy to do that offline. Thank you.
Brilliant.
That's a great thought. Actually, there's the Irish, who also like to be very different. By that I mean the people in the Republic.
Yeah.
They have a Mediation Act which enshrines some of the things we're talking about. Actually, so there we are. Many times the Irish are ahead of us.
I'm half Irish as well, so I'm in both camps there.
Oh, well done.
Oh, Graham,
Dave,
wow,
Dave,
you're definitely a good contact.
Okay, Dave,
Thank you.
did you want to make a comment, being Welsh, of course?
Yes, thank you. Given that my given names are David Wynn, I can throw some light on this. 3 people who were due to be on today all work for the Welsh Government.
Okay.
So we've definitely got contacts there if you want me to put you in touch, Rebecca.
Thank you, that would be great.
I also host whenever there's an international on mediation and RJ in Wales group.
Just to clarify, the CMC is only responsible for England and Wales, so that's why we're a little hazy on the situation in Scotland, because it doesn't actually fall under our remit, and Northern Ireland the same. So just bring that up.
Okay. Any other questions?
Roger Levitt's got one, Michael.
Roger, yes. Good morning.
Yeah, good morning, everyone. I was going to share some positive experience with what we typically call the gatekeepers, the dispute resolution solicitors. I don't know whether other people have shared this experience, but I found over the years I've been mediating, there's been a sea change in the way that the dispute resolution solicitors embrace mediation, and I think that that's obviously very good news for mediators. It's also good news for their clients as well. But having gone from a situation where I qualified, where the dispute resolution solicitor was a litigator, and a litigator often being of the type that we used to call Rottweilers. Well, they pretty much died off in my experience, and so we're working very collaboratively, in my experience, with dispute resolution solicitors.
Yeah, and I spoke at London International Disputes Week yesterday, actually, which was mainly comprised in-house solicitors, and you know, I've spoken at LIDW before. What was really interesting this year, certainly yesterday's sessions, was there was so much more focus on mediation, and I think that's a real positive. And in fact, the keynote speech at the end of the day was from a judge from New York, who was talking about how mediation had been used to resolve the insurance claims out of the Twin Towers disaster. So, you know, it was a really positive pro-mediation experience. Any other questions?
Any other questions or comments?
Carl Islam has a comment, Michael.
Carl Islam.
Just a quick observation. It just occurs to me that the point made by Michael Cover about statutory immunity from suit is very significant for the purposes of CMC policy and engagement with other key players, including the MOD and the judges. And it's this, that some of us at the bar, I practice at the bar, limit ourselves to cases that fall within our PI cover. And that limits what we do, not just sometimes to our own specialization, for those who like me are very specialized, but it means that we are going to be in a groove, a particular groove, as we develop our practices as mediators. which deprives the market of those of us who have wider commercial negotiation skills and a broader hinterland from being available to mediate commercial disputes in a commercial manner. So the point I'm making is that that's a very important strategic policy, the point made by Michael. But it raises a broader question, which is this. What else can the CMC do when it's in brainstorm mode to actually develop ideas for broadening the potential pool of talented mediators before making submissions to government? Because by broadening the pool of talent, you're increasing the quality of the mediators, and you are also offering a service to the government that takes care of a broader range of problems.
Thanks, Carl. I hear where you're coming from. I think that you know, it's certainly something to be looked at and something for us to get our head around going forward. I guess the caveat to that is that certainly historically, we've had more mediators than we've had work. And so there has been little pressure, if you like, to broaden the pool in that we've been attempting to raise the standards of those that we've got, and also to ensure that, you know, training. Obviously, there's a high fallout from mediation training. There's a high fallout between those who pass through the training and those who then go on to mediate. You know, lots of people do mediation training for. Yeah,
that's not what I'm saying. What I'm saying, it's not the numbers; it's the quality of the mediators. Some mediators have broader experience than others,
yeah, okay,
but they're contained by the level of their PI cover. So it's not so much getting more mediators, it's offering the government a broader range of talent by extending the opportunity for those mediators who have that broad skill set to be able to take on cases that are above their level of PI cover.
That's a
qualitative argument.
Yeah, that's a tricky one for us to deal with, because the level of PI cover that you choose to take is an individual decision. So I'm not quite sure what you want us to do about that.
I think if I may make a comment, that this last renewal year was a pretty difficult one for PI insurance, and I think it's expected that this next year will be softer. Certainly a number of us found that our PI
I think Michael's reached the ceiling of his PI cover, I think.
Yeah, he's just dropped off there. Dave Owen, you wanted to make a comment, I think. Except you're on mute.
Yes, thank you. On the same point, I'm just wondering if anybody here knows of anybody who's been successfully sued in their role as a mediator, because I don't think I've ever come across anybody that I know of. Anybody know?
I've not even heard of anybody who's been sued, let alone successfully, but I'd be interested if anybody has had someone take a pop at them.
I guess from our perspective, you know, it's one of the reasons why the complaints and discipline side of the organization is super important, because it is that hopefully that will prevent disputes about mediators' behavior getting to that level. I mean, we obviously routinely have probably 5 or 6 complaints a year, which are then independently investigated. And I can't talk to specifics, but I've been doing this job for 4 years. I think I can think of one person in that, one mediator in that time that was actually found to have not necessarily to have been close to the line, let's say that much. You know, so I think that gives you confidence in both the the process and also in terms of mediators' behaviour. I think that's all encouraging. Carl, to go back to your point, I understand where you're coming from. I'm just not quite sure in the current situation what we could do about it. It may be something that certainly, if we get beyond ARM, if we get into a post-ARM world where mediation is very much the norm, then sure, then I think that's a different question. But right at the minute, we've scant enough leverage with government as it is without making bigger demands. So we just got to focus on what we think we can achieve, and that is obviously the bigger building blocks of getting it into the system as a sort of integrated part of resolution.
A further comment, if I may. The RICS now only accredits evaluative mediators and has done for a few years. So that's another spin on the same issue.
Okay, anybody else got any other comments? I think Rebecca's had to go, hasn't she, Paul?
No, I'm back. I'm sorry.
Oh, you're back. Oh, that's right.
The Wi-Fi decided to stop working.
I think we all had a bit of a wobble just then. Anybody else got any comments or questions?
Okay, well, maybe I could throw out a question.
Yes, of course.
What do you all think the CMC could be doing that it's not doing?
Okay, anybody got any thoughts on that? Carl?
Yes, I qualified as a Zoom mediator, not a Zoom mediator. I qualified through the Society of Mediators last year and undertook the Zoom mediation course because of COVID, and then completed my observations, which in fact were also Zoom observations. Now, the observations count because they're Zoom observations, and I've clocked up all the hours with the solicitor doing that. But the course itself requires the recording of a 2-hour mediation, 2-hour mock mediation, which the SOM are in fact running. They're running this in June, and I'm attending that. I'm just wondering why that's necessary and whether or not you're going to review the policy about that, because in fact, in my experience, Zoom mediations are more intellectually demanding than mediations in person. Therefore, logically, it makes no sense to make this distinction in practice.
Okay,
I'm going to hand over to Paul for that one, because I know.
Yeah, I'm glad, Carl. It's almost like I paid you to come up with that question. Thank you very much. Perfect. Right, a couple of things. As far as think back to 2020, in 2020, all of our training was run face to face. Okay, COVID came along, the world went up in flames, and we held a consultation with our training providers about, okay, how do we meet this? And if you remember back to March 2020, everybody thought this was going to be over in kind of 6 or 8 weeks. Little did we know. And our training providers were split pretty much right down the middle. Half of them said, do you know what, we can do mediation training online, not a Trump, no problem. And the other half said, no, absolutely not. Mediation is a face-to-face skill, and it needs to be trained and assessed face-to-face. So we faced a bit of a tricky scenario, and the only way to the mediated solution was to essentially have a hybrid. So it was to allow online training, but to specify that at the end of the training there had to be a 2-day face-to-face confirmation phase, and that was the only way we could sort of get everybody on board. Obviously, we're all clever buggers in hindsight, and 2 years down the line, our training providers have been saying to us, why are we doing this face-to-face thing? It's not necessary. We can do it all online. Since the COVID restrictions sort of lightened, we've now got extensive feedback from trainers saying, look, we've run the face-to-face thing and it just wasn't necessary. So we have literally just last Wednesday finally put a cap on it, and from now on, all training will be online, and all assessment will be online as well. Now, to go back to your question, why is there the requirement for a 2-hour video? One of the things that we haven't had previously, and perhaps has been highlighted even more through COVID, we've got 21 training providers. And whilst all of their courses are approved with the CMC, are accredited with the CMC, what we haven't, that was the approach that was taken moons ago. I don't know how long ago, but certainly prior to my time. We've essentially been accrediting the courses, not the output. And, there's been a question kicking around, particularly amongst senior mediators, whether the standards of those coming out from different training providers is at the same level. And do you know what? It's not. And the reason it's not is because we've got 21 training providers, all training in a silo, all doing their own thing, all wary of what their competitors are doing, and therefore, keen to keep confidential the ins and outs of how they train. And so there's been no moderation across those 21 because the courses are accredited, not the output. So we've just basically screwed that up and thrown it in the bin. And what we're moving to now is a moderated output. So all of those who go through training will submit that 2-hour video assessment, essentially. It's not for the CMC to examine each of those individuals. Do you know what? Because we don't have the resources to do it. So what will happen is that the CMC will choose at random samples from each of the training providers through the year, and will just accredit those or just check those against our sort of moderation standard. Is the individual above the minimum standard that we expect of a CMC mediator? Yes or no? Okay. If they're not, then we'll go back to the training provider and say, right, okay, you passed this person. We don't think that person was above the quality line. Can we look in more detail at some of the other people that you've passed to make sure that you are passing people above the quality line? Okay. So it is a training provider focused solution, which allows us to ensure, go back to what I said earlier about making sure that government is confident that mediators are safe to mediate. So we're focusing very much on the output without saying without being prescriptive to our training providers, because some training providers may want to train in a particular way. So take yourself, for example. Obviously, you have got lots of dispute resolution experience before you decided to become a mediator. So the training that you need would be different from the training that I would need as a non-mediator starting from scratch. So we've tried to give the training providers plenty of freedom to operate, to get their candidates above the standard, and also to allow those training providers to stretch the really talented people by pushing them harder, essentially, so pushing the standards up. But from our perspective, as long as they're over the quality line, they're over the quality line. And what we want to do over time is gradually move that bar up. But the first thing we need to do is make sure that all 21 are training above the minimum standard. Thank you. Does that very long answer to a very short question? But...
Okay, anybody else? I just have one thought, Paul and Rebecca. Again, where one travels abroad, one tends to find one body which is able to regulate, recruit, and accredit mediators. What prospect might we have? I mean, how many? We've got 21 trainers, and is that the maximum number that people who are or organisations that are entitled to accredit mediators? 21.
That is the number of training providers that we have accredited at present. There is no limit to it. We just haven't had anybody else come forward who wants to fill that space. Now, imagine a scenario where the government says, okay, we're going to introduce ARM in 18 months or 2 years' time. We go back to the point that I mentioned to Carl earlier, i.e. historically, we've had more mediators than we've had work. well, potentially we might very quickly flip into the opposite situation. And there I would see that either the 21 that we have already will scale up their operations and probably breathe a sigh of relief, or, you know, new players may come in. And as long as the output of their training courses is above the quality line, we're not trying to regulate the market. We're just trying to ensure that those mediators who are CMC accredited are, you know, above the quality line, behave in a professional manner, you know, have insurance, sign up to CPD, all the sort of 5 tenets of being a CMC member, the 5 reasons why we think, you know, a CMC member is a better option for an organization or a member of the public to use than one who's not.
Okay.
And yes, we are looking strategically at the market and how to ensure that there is less fragmentation and less or more unified voices. And that's something that we are actively talking to government about at the moment.
Yeah, we've got a couple of things on chat. I don't know whether you've had a look at them. Isabel Phillips from the Chartered Institute has a question to Paul. What criteria or system are you using in order to review the videos that you were talking about, and are you making those public?
Am I on mute? No. That criteria has just been changed as of last week, and it's still in consultation phase with the trainers. So yes, we will definitely be making it public, should be available on our website soon, but we just want to hold a consultation, open brackets, question and answer session with the training providers, because it's them who, you know, we think what we've got is good, but we just want to double check that in reality it makes sense going forward.
Okay. Carolyn Jones has a comment. Training is a cash cow. Why are the 21 providers? How many new mediators are qualifying every year? And why are we deluding so many people that there's a living here?
As I've said already, it's not our role, you know, go back to where we started this, you know, we're here to educate and promote. We're not here to control the market. That is left to market forces. I would also say that, you know, the vast, not the majority, but I think it's something like 40% of those who go through mediation training never intend to become a mediator anyway. You know, they do it as professional development for other areas of their professional life. So it would be very difficult, you know, how would we control that? Set a quota? Well, bear in mind that, you know, CMC is only resourced by its members. I can tell you now what would happen overnight if we set a quota is that all those training organizations that didn't get, you know, sufficient numbers would simply go outside the CMC. We're in an unregulated market. If this was a regulated market, if you were training, I don't know, doctors, then you could say, okay, there will only be 200 places a year. Great, but we're not in that scenario. So there's no point us setting rules that people will just stiffly ignore and carry on as before. And that has a negative effect on mediation, because it sends the sector in exactly the opposite direction that we want to go, in that we end up with, you know, everybody just doing their own thing. And that is hugely dangerous, especially at the minute where we're trying to get into government funded, schemes where, you know, there is a huge area of opportunity at the minute, but it's also a huge area of risk, because if the government brings in mediation and mediators go in and mess up, the media will be all over it, and we won't be back to square one. We'll be 30 years in reverse. So we've got to pick our battles, I think.
Yeah, no, it's an interesting point, and I think I'm right in saying that until comparatively recently, the BMA restricted the number of doctors who were able to be taken into medical school, and look where that got us. It's a complete disaster. Dave, you had your hand up.
Yes, I just wanted to make the point about the difference between community mediators, which falls within the CMC, and the kind of training they get. Should the CMC be looking to make it abundantly clear that there are different types of training depending on which kind of mediator you are?
Yes, absolutely. And, you know, I don't think anybody that represents the CMC would make out that we're community mediation experts. We're definitely not. Okay, we're feeling our way into community mediation. Why are we doing it? Essentially for two reasons. One, because as you'll know, there is no national body for community mediation. And I think we all recognize the huge benefit that community mediation can provide. So we feel like it should be supported. Secondly, it's because we think that there's a huge opportunity with government around community mediation essentially because of the cost-saving benefits of community mediation. There's been some work done in terms of the sort of cumulative cost saving of utilizing community mediation rather than, you know, things going to court and issues with housing, etc. And thirdly, if I'm being brutally honest, it's because, as I said previously, CMC is a charity and we walk a line between professional members association and charity. And by bringing in things like community mediation and peer mediation, it helps us to ensure that our narrative as an organization is firmly in the charitable sector. And as I said before, having charitable status is a huge advantage. You know, it makes it much easier to talk to government about this stuff because they don't think we're going to line our own pockets with it. So for all three of those reasons, community is something that we want to support more in the future. And we've got a fairly new community mediation working group, but, you know, it's obviously not an area that we've historically worked in, and we're very much trying to support what's there rather than reinvent the wheel.
Yeah, that's an interesting point. Is it? Do you think that there might be a feeling in government and the civil service that mediators make too much money?
I'm not sure that's what's driving it. I think that they don't want to be seen to be favouring one commercial organisation over another. Yeah. So I don't think individual, and actually I think one of our concerns at the CMC is if we do get automatic referral to mediation, and there's talk of it following the Ontario model, where actually the fees for that mediation are very low, which would, there is a concern within some, with some mediators that there will be a drive to the bottom in terms of what people can charge for mediation. So again, it needs to be handled very carefully.
Yes, and we're kind of rather hamstrung in that area by public procurement rules, are we not? I mean, that's one of the things I've encountered in trying to convince government of the merit of dispute adjudication, avoidance and adjudication boards. So that's another concern. Yeah. Don't ask me about my views on public procurement rules. That's another subject for another day. Anybody else? Anybody else got their hand up? Carl, go ahead. Yeah, you're muted, Carl.
Just a quick point for Rebecca, which Rebecca may be aware of anyway. The Chancery Bar Association run a scheme for advocates, which is called the CLIPS scheme, which is a free advocacy, a free advocacy service. And advocates sign up for that in advance of the days that are available when this scheme is running in the High Court in London. And also the Central London County Court are operating a similar free advocacy scheme. Now, this is very good for barristers who want to, broaden their skills as advocates or who are starting out. And even for seasoned advocates, it's good because we're not always in court all the time. So particularly at the Chancery Bar. So I was just wondering whether or not on your, for the purposes of your discussions with the government, it might be worth considering developing along with the Chancery Bar Association, for example, a parallel scheme for mediation, a free mediation scheme.
Yeah, that's a very interesting idea, isn't it? There's a terrifying amount of ignorance when one's mediating, mediation involving what one broadly call the public sector, in other words, the government and quangos and things. And some training in negotiation and mediation advocacy there might be very useful, actually. This is probably be more for the end users than the lawyers, but probably even some of the lawyers could do with some training as well. Paul,
do you mean matching it? Does it work so that you have people who need the advocacy and it matches those people with people who can provide the advocacy for free, who have free capacity?
Yeah, if you're a member of the Chancery Bar Association, like I am, you have to have a background in Chancery work. So technically you have to be up to the challenge. That means you have to be able to take whatever's thrown at you for the purposes of what comes along on that day in court. So these advocates sign up and say, I will be available to sit in a room in the Rolls building. And if a litigant in person wishes to have legal representation because they can't afford a professional lawyer, they can come and see me. They can give me 30 minutes to read the papers and I will go in and make submissions on their behalf.
Okay, so I think that is a really interesting idea. I think my initial reaction to it is I don't know how it would work in mediation, because if you're a litigant in person, you've got a court hearing, that's within your control. I suppose if you're mediating and you're a litigant in person, you have to get the other team to turn up. And so I'm not sure how, I don't think it could be quite that spontaneous.
It could be very simple. You could have a direction, you could have guidance in the civil procedure rules saying to the judges, look, if you are going to direct that there must be mediation, whether an application has been made and this is consented to by all the parties, or you're going to impose it. And in fact, I've written on this subject and been published by Oxford University Press in an article I wrote about JENE a couple of years ago. The court does have a power to impose compulsory mediation. The government are not pro-compulsory mediation, for what I understand are ideological reasons and other reasons. But the courts actually have that power, and the Rules Committee, as I understand it, are working to provide guidance. So you can have a very simple conceptual framework whereby there is guidance in the CPR for counsel and for solicitors and for the judges saying, if you give a direction, make a direction that there must be, the case must be stayed and there must be mediation, a one-day mediation. That one-day mediation, for example, in the Central London County Court, could take place theoretically or anywhere, could take place by Zoom. And then it's not a question of the other parties consenting if it's mandatory, if the other party is legally represented, because they have to be there. If they're not, it's going to count against them. So it takes place by Zoom. So it's imposed, it takes place by Zoom. And then in advance, you say, look, if you want legal representation, you're a litigant in person, we have people who've signed up to be available on these days. If you'd like it to be on one of these days, you can contact one of these people through us and they will be part of the Zoom call, but you'll need to send the papers to them a couple of days in advance so they can read them and prepare, that kind of thing.
Okay.
Yeah, that's quite interesting. I think probably we're almost getting to the point where we should just draw this to a conclusion. That Dave has made an interesting observation on chat. Dave, if you don't mind me reading it out, that some mediations can't or don't end up in court. And I think one of the things we may well have to think about is detaching mediation and other forms of ADR from what we might broadly call litigation. In other words, perhaps what we're about is non-court based dispute resolution in all its forms. So I was just going to thank Paul and Rebecca and Paul for coming along and sharing their thoughts. A very interesting debate, and I think we wish you every success with trying to persuade the government of the wisdom of what we're all trying to achieve. So thank you very much indeed, and we look forward to a further update in a year or so's time, which will be very nice.
Thanks very much, Michael.
Well,
Thank you.
So we're very impressed, and I think terrific work, you know, bearing in mind where the CMC's come from. And I think it's now, it appears to me at any rate, to be a highly relevant, highly relevant organisation for both
Thanks.
mediators and users. So thank you.
Thank you, Michael.
Thank you.
All.
Just you're welcome to stay on while we just sort of natter and do a few parish notices and stuff. First, just to remind everybody, the session has been recorded and will be made available online in a day or two. Just going on, before we do the new people attending for the first time, the next meeting is going to be, I think, Dave, on July the 13th, isn't it?
I will just look it up. I think
yeah,
you're right.
The 13th, yeah, where Mrs. Justice,
yes, correct.
Sorry,
yes.
Lady Justice Asplin.
The Honourable.
The Honourable, or yeah, the Honourable, late, whatever. Anyway, Sarah Asplin, who's the judge who's in charge of ADR as peers and working with under Geoffrey Boss, is going to come and actually give us about 3/4 of an hour of her time between 9 and 9:45. So again, we'll flip it over as we've done today, and just share some thoughts. So it's an opportunity, and this has been a perfect lead-in. I'm sure you'll all agree to actually hearing what Sarah Asplin has got to say, and also asking her some suitably penetrating questions. So the flyer will go out for that very shortly.
Michael, I'll send out a save the day on that today or tomorrow.
Excellent. Okay, thank you. We had just short of 40 people on today, which was great. And who amongst those do we have who are new people attending for the first time? Right, Emek Delibas, I hope I've got that right. Yeah, do you want just a sentence or so? Welcome, please introduce yourself.
Yes, of course. Hi, everybody. Thank you to both Paul and Rebecca for an extremely insightful conversation here. I'm a lecturer at Kent Law School. I'm also a mediator and a solicitor. I used to be a corporate lawyer prior to joining the law school. So I'm here actually really because I teach mediation, and I'm curious to see what the future holds, because we have an increasing number of students. I think somebody mentioned earlier in the chat, students are having to diversify what they're doing because they can't get training contracts. And so there's an increasing sort of interest in mediation. And I also have that interest as well.
Thank you.
Lovely to meet you all.
Who else have we got? Martin, do you want to point somebody out? Oh, here we go.
David Mills.
David Mills. Do we have David Mills on? Oh, David, there you are.
Yes, we do.
Good morning. Yeah, hello.
Hello. Sorry, can you hear me?
Yeah, absolutely.
Hello there.
Yeah, carry on.
Hi there. My name's David Mills. I've just done my first mediation training, and so I'm an extremely enthusiastic young mediator looking for observerships and to get into this. My background is I run a theatre company for about 25 years. I did a law degree way back in Australia back in the day. I've got a background in coaching and NLP and that kind of stuff. COVID had a big impact, obviously, in traveling theatre, touring internationally and all of that. And so I've re-entered my degree and that interest, and it's been very interesting to hear the state of the play and where things are developing. So thank you very much for having me, and I'll be joining more and more often. And obviously, if there's anybody who has an observership that they can help me with, I mean, that's one of my reasons to be around as well. So thank you.
Thank you. Okay, so who else have we got?
Sally Atherton is new today.
Okay, Sally Atherton, we'll come to you as Adora in a moment. Sally Atherton.
Good morning, everyone. Yeah, so my background, I was a barrister in practice for 13 years in London and left to live in Cornwall in the 2000s. And I've worked down here as a registrar, birth, deaths and marriages registrar, not a medical registrar. I haven't retrained to that extent. And I've been thinking about retraining as a mediator. So currently I work part-time for Cornwall Wildlife Trust, but would be really interested in looking at retraining now as a mediator to work alongside that. So yeah, I'm really early stages, and thanks for letting me join in. It's
our pleasure.
enlightening.
Good. Isadora?
Yes, hello. Thank you very much for today, for this very interesting and insightful discussion. So I'm Isadora Tahmadzidi. I'm an attorney at law. I qualified in the Athens Bar Association in Greece. So I'm an EU qualified lawyer. After finishing my LLB and LLM at King's College London here, but I have a huge interest in mediation. I completed the training with the London School of Mediation about 2 years ago. And yes, I'm currently in the process of registering with the CMC, so completing the required observations. Yes, I'm really interested in the mediation field, and thank you very much for having me here today.
And you're observing me on Monday?
Yes, yes, that is
well
correct.
done, jolly good. Well, we practice what we preach, Dave. Well done.
I hope so, yes. I think, Isadora, you're only in the UK till the end of this month, is that correct?
Yes, yes, that is correct. But of course, I have the flexibility of coming and going very often, as I'm currently working in Paris. So I have this opportunity with a mediation observation. So I have this kind of flexibility for anything that is required for this type of work.
Okay, we've probably got time for a couple more, and then we'll leave the meeting open if people want to network. So any other newcomers? Martin, can you point us to anybody? Was that Loveday? Oh, we can't hear you. You're muted.
Hello, yes, my name is Loveday. That's my first name. So I started off in community mediation before moving over into SEND. I'm also trained in restorative practice. I mentor mediators. I've trained people to be mediators, and I wrote the first SEND accreditation course as well through Releasing Potential. I'm currently on the panel of mediators at Global, and that's how I'm getting most of my work. I'm qualified in civil and commercial, but I haven't done a live case yet, so that's something that I'm looking to move into. And yes, due to some technical difficulties, it's finally time for me to come and join this group. So I'm very glad to, and found it's very, very interesting, and looking forward to connecting with more of you and listening to more of these mornings. Thank you.
Okay, thank you. For my benefit, forgive my ignorance, what is SEND?
Sorry, special educational needs and disabilities.
Okay, thank you.
So I mediate parents, schools, and local education authorities.
Yeah, got it. Okay, anybody else? Last one. Last person attending the first time. Any more? No, I don't think so. Well, thank you very much, everybody. Is there anything else that we need to say apart from the reminder? The next meeting will be July the 13th, and Dave will save the date, and then we'll send out the flyer. Is there anything else we need to say, Dave?
I just wanted to say that if anybody wants their email addresses shown on the list of attendees, if you can let me know if you haven't already done so, so that people can contact you outside the meeting.
Okay. So Martin, should we leave this open for another 15 minutes or so if people want to chat? And thank you very much, everybody. Have a great day, and we look forward to seeing you next time. Thank you. Bye.
Thanks, Michael. Thanks, Martin.